Why won't the church just follow the law? This was a common refrain during the public hearings on the Fairview Temple. Many felt that because the temple was being built on land zoned residential with a 35-foot height limit, that the law also limited the temple to 35 feet, the size of a house. Unfortunately, there has been much confusion about how Fairview zoning law applies to churches. If you think you can handle a little boredom, let's venture into the actual law. Say you want to build a church in Fairview. The first thing you will discover is that there are no areas in Fairview that are zoned for churches, not even the commercial district, as some have assumed. There is simply no place in Fairview where you have the guaranteed right to go and build a church. The only way you can build a church in Fairview is by purchasing land and then hoping the town council grants you permission to build. Contrast this with sexually oriented businesses. Town ordinances specifically recognize their First Amendment rights and allow them within a certain zone. But the town has not made a similar accommodation for the First Amendment rights of churches. So what does the process of getting permission to build a church look like? You have to apply for a conditional use permit. The zoning law allows the town council to approve a conditional use permit for a church in any type of zone, even residential, which is where almost all of the Fairview churches are located. And that is not unusual. Churches historically are built in neighborhoods. In fact, the tallest churches in Collin County are in neighborhoods. Legally, what you are asking the town to do is rezone the land to your use. It is a custom zone. It is not a variance. A variance is asking the town to deviate from zoning laws that apply to you. A conditional use permit is asking the town to create new zoning laws customized to your intended use on your specific parcel. When the town council approves a conditional use permit and attaches a height condition, that height condition becomes the law. Town ordinance specifically states that the underlying height limit goes away. The underlying height limit is only relevant for non-permitted uses. For example, if you had a church and a house on the same lot, then the conditional use permit conditions give the height requirement for the permitted use, the church. And the old zoning height limits would only apply to the non-permitted use, the house. Do town ordinances put any restrictions on churches that get a conditional use permit? Yes. Town ordinances have a number of requirements that apply to all churches, but these relate to things like setback from property lines, parking, and minimum lot size. They do not restrict the height of a church. The town could have included that in their ordinance, but they didn't. Well, until they amended the law a few weeks ago for new conditional use permit applications. So if the town ordinance does not restrict the height of the temple, what can the town council take into account when they decide whether to approve a proposed height condition? The only really relevant factor that the town ordinances allow the town council to consider is, quote, the aesthetic appearance of the use and other sensory effects that the use may have on the established character of the neighborhood and the property within the town as a whole. But when I get to the video about federal and state laws that protect religious exercise, I will explain how those religious freedom laws prevent the town from considering aesthetics. And that is because the law recognizes that vague aesthetic considerations are fertile ground for intentional and unintentional discrimination. That said, check out my other video if you want to see the character of the area where the temple is being built to see how it actually fits in. Some have conceded that the 35-foot limit does not apply to churches, but instead maintain that the precedent set by existing churches limits the height of new churches. But there is no ordinance or law that supports this sentiment. And if it did, then the applicable precedent would likely be the 154-foot bell tower approved in 2006. Check out my video on that subject if you want to learn more. One final point I would add is that Fairview is not unique in its 35-foot residential height limit. That is a standard height limit for suburban areas. Fairview's surrounding neighbors like Allen, McKinney, Lucas, Frisco, Plano, Melissa, they all have 35-foot height limits in their single-family neighborhoods. But that has not stopped them from approving churches in those neighborhoods, including many that are much taller than the temple.